Hello and welcome. This is our attorney lecture series, our first one in quite a while. We're here at the Fort Bend County Law Library, and we're pleased and privileged to have Andy Scott here giving a presentation today on expunctions and orders of non-disclosure. Annie is a longstanding attorney practicing primarily in criminal defense here, and she's a regular here at the Fort Bend County Courthouse and here at the Law Library. And she's a good friend to us, and we're lucky to have her speaking and providing some good information. And with no further ado, here's Miss Andy Scott.
Thank you, Jonathan. So good afternoon, everyone, and happy Juneteenth. I hope that your day is going well, and that today I will be able to provide you with some valuable information on the topic of expunctions and non-disclosures. So, as you all may be aware, expunctions and non-disclosures fall into the realm of criminal law or quasi-criminal law because they're actually civil. An expunction happens after you have, been arrested, whether it be custodial or non-custodial, and you need to have that arrest and even that record removed from your criminal background. And so what you do in those instances is either try to handle it on your own, or you call a great criminal defense attorney who is familiar with handling expunctions. The expunctions are intended for those who have been wrongfully arrested or wrongfully accused, and they need to clear their record. And so the first step is to make sure that your case is closed. You cannot get an expunction on a case that is still pending. Even if the case is non-active, you still cannot get your expunction until your case has been disposed of. There are several ways that you can have your case disposed. One of them is that your case will be dismissed. Another way is to take your case to a jury trial or a bench trial, and your case, or you are found acquitted. You have been acquitted. So if either of those two things have happened, you are eligible for an expunction. A few other ways that your case can be expunged is if, say, you've received a pardon by the governor or even some other higher up, or if your case has been no-billed. So when your case goes to a grand jury and they review the evidence and they review the presentation of the DA, and in some cases, the defense attorney's grand jury packet, if they decide that there is not enough merit to proceed and take your case to court, then your case will be no-bill. That is also eligible for an expunction. The last, and the way that we probably won't spend a lot of time talking about, is identity theft. If your identity has been stolen and someone has given your name in a traffic stop or in some other way, written a check that wasn't actually yours, but it's from your checkbook or with your name, and they've stolen your identity, you may have a criminal record because of their actions. You can have that record expunged as well. But we won't go into that, but just know that that option is available to you. So in the case of a dismissal, this is just a straight, your case has gone to court, the DA has looked at it, and they have decided that either they don't have enough evidence, or they don't have a cooperating witness, or some other reason. No matter what it may be, your case is going to be dismissed. And once your case is dismissed, you have an opportunity to go forward and get an expunction. You're entitled to an expunction. And when your case is dismissed, sometimes that's called actual innocence, but sometimes that's just that the DA doesn't have enough evidence to proceed to a guilty verdict. Now, dismissals are not conditioned upon anything. So if you had to complete some sort of condition, or you had to participate, say, in a class, or a probation or something like that, then those are cases in which you could still be eligible for an expunction, but they're a different type of expunction. They're still going to go through the same process, and you're still going to be able to get your record and your criminal record expunged. But it's just a matter of how you get there. Dismissals come in different forms. As I said, there are different ways to get there. Sometimes if your case has been dismissed and the statute of limitations hasn't run, in misdemeanors it's 2 years, felonies vary depending on the offense. But if the statute of limitations hasn't run and you're seeking an expunction, sometimes the court or maybe even the prosecutor may object, because if your case is dismissed, they still may have the opportunity to refile. If they gain or gather other evidence, they can seek to refile your case, basically reinstate it, and go through the court process again. So you want to make sure that if your case is dismissed and you're seeking an expunction, you might consider looking to see if the statute of limitations has expired, or your lawyer may do so that when you expunge your case, you don't have to worry about anything coming back. If it gets all the way to expunction and the judge signs off on it, you're probably in the clear. But you want to make sure to at least take that step before you do it to see if that statute has expired. Another thing that you may want to keep in mind is that sometimes there is a waiting period that goes along with the dismissal. And that may be a waiting period of the state gaining other or trying to obtain other evidence from the arresting agencies. It may be the state trying to obtain other evidence from maybe medical records or witness statements or witness locations. So sometimes there is a waiting period attached as well. And you want to make sure that you hire an attorney that is experienced with doing expunctions to make sure that all of these things have transpired and have lapsed, so that you're not having to either wait or come back because it's not able to be done at that time. Sometimes that waiting period is also because of, like I say, evidence that hasn't been obtained yet. But when that hasn't happened, sometimes that means the indictment hasn't been presented to a grand jury, or it means that the information hasn't been filed in a misdemeanor case. Those are all in the waiting period. So it's very important to make sure that when you are looking to either, get your case dismissed, you're considering all these different factors. And so sometimes it's a little scary to go on your own and do this. It's always best to try to consult with a criminal defense attorney or an attorney that is familiar with handling expunctions for criminal cases. Class Cs are a different topic. And with Class Cs, I'm talking about traffic tickets for no insurance, registration. You usually don't get arrested for that, but you could. Those are offenses in which you could have a custodial or a non-custodial arrest. And so when you are considering getting an expunction on a Class C, you want to make sure, again, that your case is not active, that it has been disposed, and that it is, in fact, a Class C and not one of the higher level offenses, because they're treated a little bit different for expunctions. You want to make sure the statute is run, the waiting period has expired, and that your case has been dismissed. If you have received a Class C or the other offenses, you want to make sure that the prosecutor is certifying in that expunction that there are no other records needed, and that there are no records that are going to be kept for further investigation. And so that's why it's really important to make sure that your case is completely finished and that it's not going to be brought back. If the prosecutor doesn't certify, or there isn't any need to certify, then you will be able to proceed with your expunction, and you won't have to ultimately rely or worry about this case being revived, meaning brought back. If there is a need for the prosecutor to or if there is a situation in which the prosecutor is not going to certify, you will need to include that language in your order, which goes along with the filing paperwork, which we'll talk about just a little bit later. When your case is dismissed and you sought an expunction, and that expunction has been granted, your records are deleted, they are destroyed. And so they will not be able to be used in any further cases. They won't be able to be used in any background checks. They will be destroyed. And the way that that happens is once that order is signed by the judge and the prosecutor has signed it and your attorney has signed it, those records are certified and distributed to all of the arresting agencies, as well as to all of the other government agencies that may contain your record. So for example, if you are arrested by Katy ISD, which is a school district, and you're an adult, your record would be with Katy ISD. Your record would also be with the arresting agency, which may be Katy Police Department. Your record would also be with the county clerk. So in this case, Fort Bend County Clerk. Your record would also be with the Fort Bend District Clerk. Your record may have also found its way to a third party. And those third parties purchase records, criminal records or arrests from the county clerks as well as other entities so that they can have that information for, say, credit checks. They could also have those records for apartment checks or leasing information. So you want to make sure that, and you need to know that when your record is expunged, that all of these agencies and all of these entities are supposed to destroy your record. It should never be able to see the light of day again. It should be gone. And if you have a qualified, criminal defense attorney do that for you, then that should not be something that you worry about. There are also what's called discretionary expunctions. And discretionary expunctions are exactly what they say. If a judge has a very extraordinary or unusual case and the case wasn't actually dismissed, maybe it had a probationary sentence or maybe it had a jail time sentence or something of that nature, the court can, in its own discretion, deem that an expunction is necessary. They're not mandatory, they're discretionary. And so if the judge sees or decides that in his discretion or her discretion that she'd like to grant you that opportunity to expunge it from your record, I'm sure that she will tell you so, and that will be something that you will be able to do. Now, this is a unilateral position, and so if the prosecutor objected to this discretionary expunction, then you would have a little bit of a fight. It's not going to be automatic. So either the prosecutor or the judge can decide on a discretionary expunction, and both of them would have to agree in order for it to be done. Another thing to keep in mind with expunctions is that it must be done before a trial on the case has happened. So if a trial has happened, you're not going to be eligible for an expunction unless you are acquitted, okay? Usually, like I say, an expunction comes from a dismissal of some sort. So that's always before a trial. But in the case that a trial has happened and you were not acquitted, you're not likely going to be eligible for an expunction. If you are acquitted, you should be. Again, your expunction means that there is a total destruction of all files and all records that happen after an arrest. An arrest is when you have been either put into handcuffs and taken into the jail, as well as a non-custodial arrest. If you have been summoned or you have been served with a case because you have pending litigation from a criminal case, that is still a non-custodial arrest because you are told where to appear and at what time to appear, and thus you have been, by all means, arrested. And in fact, when you get to the court for that first court date, you're likely to be told to go over to the arresting agency and be fingerprinted as well as to be photographed. And that is an arrest, even if they don't keep you there behind bars, which we hope they don't. We are also going to talk about non-disclosures because I've spent a little bit of time talking about the expunctions, and I want to talk about the non-disclosures. So non-disclosures are a little bit different. It's still a way for you to have this criminal background sealed from your record and not used against you in most instances, but it's a little bit different. With the non-disclosures, you're not going to have your records destroyed. So if you have picked up a charge and you've gone to court and you have an attorney and your attorney's worked everything out and you accept a nice plea deal of a deferred adjudication, you are going to have to complete some conditions. Those vary from community service to a fine to court costs. It could also be a class such as anger management or anti-theft or maybe a family violence class. You are going to have to do something in order for your case to be disposed. And those requirements and those conditions are what entails the fact and the difference between the expunction and the non-disclosure. Expunction, again, is a dismissal or an acquittal. A non-disclosure means that you did take some sort of probation or you had to complete some sort of conditions in order to get to the disposition of your case. So when you apply for a non-disclosure, again, you're also going to have to do a petition. You're going to have to do an order. You could do these things on your own, but that is up to you. It's always better, again, to have a qualified criminal defense attorney do these for you. But if you so choose, good luck. With the non-disclosure, you cannot have any prior convictions and you cannot have completed any deferred adjudications ever. So if you're seeking a non-disclosure and you've been convicted of 3 felonies, 5 felonies, or even 1 felony, the prosecutor is likely to object. And if the prosecutor objects, you're going to have something of a mini trial before the judge and, explain to the judge why it's in the best interest of justice to grant you a non-disclosure when you have these other cases in your background. And so that's something, again, you work out with your attorney. You also can't have been placed on deferred for more than 180 days. So if you were on deferred for 5 years and you have other convictions or other deferreds ever in your background, then you're not likely to be eligible for a non-disclosure. But again, it's always best to check, with a criminal defense attorney. There are also what are called automatic non-disclosures, and those are not automatic, as they say. You still have to do something. You still have to take some action in order to make them happen. But the automatic non-disclosures are such that the applicant doesn't have to file a large petition, nor do you have to give any notice to the state. But it's required if you provide to the court any evidence that makes you eligible for the automatic non-disclosure, and you pay the $28 fee. So what you're going to have to do and the action that you're going to have to take in order to get the automatic non-disclosure is, write a letter or type up some sort of pleading, usually 1 page or so, that says that you are requesting a non-disclosure from this court because you've completed everything, you don't have any prior convictions, and your deferred was not over 180 days. So if you do that, the court will review it. If you've paid your $28 fee, the court should grant you the automatic non-disclosure. So there are a few other rules and conditions that you have to know about when you're seeking a non-disclosure. There are certain offenses that are not going to be eligible. For instance, any of the offenses that require or that contain another person being injured. So think of your family violence cases. Assault family violence is not going to be eligible for a non-disclosure. If you have a DWI, you're not likely to be eligible for a non-disclosure, especially if you've had an accident and another person was injured. So if you're out with your friends and you get in trouble and you go through this whole court process, you complete your assigned conditions and you've finished your case, it's all over. You say, yay, I want to go get a non-disclosure now. You're likely to run into some trouble there, because if your friend or any group of friends were in a car with you and they were injured in any way, you're not going to be eligible for a non-disclosure. Same happens if you get into an accident with another party driving another car. You don't know them, but you hit them or cause them to have an accident. You're not going to be eligible for a non-disclosure. So those are things to think about if you're, before you pay a lawyer to look for a non-disclosure. You have to know what you're going to be eligible for. All right, so trying to pick up where we left off, we're still talking on the topic of non-disclosures. I did want to make a slight clarification because I made an error in the DWI knowledge. If you do have an accident, you know, and there's another person involved, whether they be in your car or in another car, you're not going to be eligible for a non-disclosure. But there are DWIs where those are not the case and you can get a non-disclosure. But there is another caveat, and that is if you test over a 0.15, you cannot get a non-disclosure. Sorry, but if your blood alcohol level is high, you're not going to be able to get a non-disclosure. So if you're under 0.15, you didn't have anybody else in the car, you didn't hit another individual in another car, then you should be eligible for your non-disclosure. So I wanted to clear that up. I hope that that resolved that issue there for you. But going on. So some of the cases that are not going to be eligible for deferred are murder, obviously, aggravated assault or aggravated crimes, stalking, kidnapping, assault family violence. Those are not going to be eligible for non-disclosure. Those are called restrictive because in some way, form, or fashion, you restricted another person. So think of it like that. If you did any of that or you're charged with any of that, you're not going to be able to get a non-disclosure. You may get an expunction if it was dismissed for actual innocence or one of the other things we talked about, but you're not going to get a non-disclosure. So for family violence, you don't have to have an affirmative finding of family violence. So that doesn't have to be there. You're not going to get it, even if you don't have an affirmative finding. There are some cases that you could have an affirmative finding, say of family violence or an affirmative finding of a weapon, and those will prevent you from getting it. But in the assault family violence case, you don't have to have that. If you have an assault family violence and you completed deferred and you were released, even if it was successful, you're not going to be eligible for a non-disclosure. So there are a few really good items here and some really good news. And it was really good for me when I learned it some time back. And that is, if you have completed a misdemeanor, okay, key is misdemeanor, probation or even jail time, you can still get a non-disclosure. Yay. That's good news because most of the cases are misdemeanors, right? And most of them are not assault family violence, and most of them are not DWIs that involve other people, nor are over the 0.15 blood alcohol concentration limit. So if that is you and you don't fit into those exclusive areas, then you should be eligible for a non-disclosure. Now, remember the earlier caveats. If you have past crimes and convictions and what was the other one? Over a 6-month deferred, then you're going to likely have a hard time getting a non-disclosure. But if you fit into that small ball that still encompasses everything, you should be able to get it. So with that being said, we can have an example of someone who picks up a theft case, right? And you were given an anti-theft class, you were given, 30 hours of community service, maybe 3 days in jail as a condition. You had to pay a $250 fine as well as donate something to Crime Stoppers. Well, when you complete your deferred for 6 months or 3 months or 4 months, whatever it is, when you complete that and your case is dismissed by law, then you can apply for a non-disclosure. If you are in that case of having a DWI and it's under a 0.15 and you didn't have an accident, you were just out drinking or you got caught with some open containers as well as a breath test over a 0.08, and you complete deferred, when you successfully complete that and you get a dismissal, you can get your case non-disclosed. So successful completion of your probation and being released from jail, including having paid all your fines and all your court costs, allows for you to still seek a non-disclosure. So that's really good news for some of you. And I hope that your case will fit into that category and this will be an option for you, because it will definitely make your life a lot easier when you don't have to say that you were arrested or charged with these things every time you apply for a job or every time you apply for an apartment, or maybe when you want to get married and your paramour's family does a background check on you, because that happens now. So it's good to say that this is not going to show up by being able to get a non-disclosure. So, you know, keep that in mind, that even if you've been to jail, even if you had to complete some conditions, as long as you're not part of that excluded group with those restrictive categories and caveats, you should be able to get a non-disclosure. Best thing is consult with a criminal defense attorney that is familiar with it so that you can have that done. So I say all that to say that having a conviction is not the end all be all. You can still, in some cases, have your background cleared or sealed, no matter what it may be. Now, if you've been listening and taken note, you'll realize that those restrictive things and those exclusive items are for individuals who usually have a background, a criminal background. They have other convictions. They have other caveats in their case that prevent them from getting it. What does that mean? That means that the non-disclosure is usually for the first-time offender. So if this is your first time ever being in trouble, you've never done anything else, you had a bad day, you had a bad breakup, you had a drink one night after the Christmas party at your job or whatever, and this is the first time you've ever been in trouble, and you don't meet all those other restrictive things, then you should be eligible. And you should definitely seek this out, because like I said, you're able to deny that you were ever arrested, that you were ever charged, that you ever completed any of these things. And that is invaluable. So keep that in mind. So now let's talk a little bit about the filing itself, okay? We'll go back to the expunctions. The petition, which is what you'll file for an expunction, unless it's an automatic, and when it's automatic, you're just making a request. But the petition for an expunction is usually about a 2 to 3 page document. You're going to be the petitioner. Obviously, you're filing the petition. You're going to include your full name. You're going to include your sex. You're going to include your race. You're going to include your date of birth, your driver's license, your social security number. You're going to include the address that you were living and residing at the time of the arrest. That's very important. Under the offense section, you're also going to include the offense. So what is it that you were charged with? DWI, theft, criminal trespass, whatever it may be, you're going to include that. You're going to include the date of the offense. It needs to be precise. You need to include the date of arrest. That also needs to be precise. If you were not arrested and it's one of those non-custodial arrests, that's fine. You don't have to include a date, but you can say no arrest so that they know that you did not skip that section. You're also going to include the county that you were arrested in, as well as any municipality if it's, somewhere else. You're going to include the arresting agency. So that could be Fort Bend Sheriff's Office. That could be Rosenberg Police Department. That can be Missouri City Police Department. Wherever it may be, you're going to include that specific title of that arresting agency. And you're going to include the criminal cause number and the court that it was within, that it was held within. All of these items that I just listed off to you are in the code. So if you're trying to do this by yourself, you definitely want to pick up the criminal code of criminal procedure, because you're going to have all these things in there. The reason being, if you don't include something and they can't identify who you are because your name is, I don't know, Tom Smith, well, guess how many other Tom Smiths there are? If it's not your social security number and it's not your driver's license number and it's not your date of birth, they're not going to know who it is. And what if you and Tom Smith had the same birthday, but he lives in, I don't know, Waller, Texas, and you live out here in Richmond, Texas? Well, they may expunge his record, but they're not going to do yours, and you're still going to have this on your background. So it's very, very important to make sure that you have all of the pertinent information that you're going to need to draft this petition. Your petition also needs to be verified. That means that there is a verification page in there, similar to an affidavit, and that page needs to be notarized by you in front of a notary. That is very important. Your attorney cannot do that. So your attorney can draft it, but when it comes to going over all of the petitioner information and all of the offense information, you need to read that information very carefully, because again, it needs to be accurate. And sometimes, you know, your attorney may miss something. They may put the wrong date of birth because they're not familiar with your date of birth. And so you want to make sure that when you are signing this verification page that you have reviewed all of these items that I've listed off, they're all correct, and you're swearing to that by signing the verification page and having it notarized in front of a notary. You are also going to include in that petition a list of all the agencies that we talked about earlier that may have your records. These include law enforcement, court agencies, central depositories, federal depositories, private agencies who purchase criminal background information. As I stated before, there are several third-party vendors out there who do purchase criminal background information from DPS, from the courts, and from other entities that have this information. Maybe even the police department, they purchase the arrest records. So you want to make sure that when you're doing your petition, you make a list of everyone that you can think of that could possibly have this arrest and this information, because you're going to want to serve all of these parties with a copy of the certified petition expunging your record, okay? Or non-disclosing your record. So that's the petition. There's a little bit more language, but that's the base, that's the most important thing, most important stuff that needs to be in it. Along with the petition is a separate document, and this document is called an order. And so in the case of an expunction, it's the order granting expunction. In the case of the non-disclosure, it's an order granting the non-disclosure. This order is almost going to mirror what you said in your petition. So that whole list that I gave you is going to also need to be in your order. So you're going to have your full name, you're going to have your sex, you're going to have your race, your date of birth, your driver's license, your social security number, and you're going to include the offense information, which is the title of the offense, the date of the arrest, the criminal cause number and court, because they will seek your records from that court. And so you want to make sure that that's there. And you're going to then include all the other language that I talked about. You want to, in the case of an expunction, include a copy of your dismissal, which you should get from the court or from the clerk's office. And that's going to be an exhibit. So you can call it Exhibit A to your petition, but you're going to want to include that. Once this is all done, you're going to file it. You're going to, it's going to go to the DA's office. It's going to go to the clerk, and then it's eventually going to go to the judge. If you have a defense attorney, they're going to make sure that all of these steps and all of these people are communicated with and that it gets pushed along until it gets to the end. But when it's all said and done and everyone is in agreement, there's no contest, there's no fight about this, then you're going to get a signed certified copy from the court. And that copy will be forever kept in your records. If you ever go to a job or a school or your paramour's in-laws, your in-laws look at this and they won't be able to see anything. And if they do, you'll have your certified copy there that says that this is expunged. If an agency, say Rosenberg PD or maybe one of the third-party agencies or any place has your record after it has been expunged or non-disclosed, you need to send them a copy of the certified order that shows that a judge has granted the destruction of it if it's an expunction and has granted a sealing if it's a non-disclosure. You need to send that to them because they are ordered by the court to delete that information or to seal that information. Not doing so and continuing to release it is actually a Class B misdemeanor, and they can be charged. So keep that in mind. If you've gone through this entire process and you've gotten it signed on the bottom line by the judge and you've received your certified copy, you can pursue ordering or instructing any other agency to delete those records or to seal those records. And if they don't, you can file charges, and that is a Class B misdemeanor. So, as I've said, with an expunction, they are ordered to destroy your records. They can burn them, shred them, throw them in the trash, which they won't do, but they are to get rid of them. The DA's office is the same. They are to get rid of them. So your name should never pop up anywhere in regard to this charge that you just went through this process for. The district court will receive all the records from the agencies. So Rosenberg PD, Missouri City PD, whoever it may be, they have to send everything they have about your case to the district clerk. And the district clerk has to then destroy them. Now, the district clerk has 30 days to destroy all of their records, but the outside agencies have to do it as soon as possible. There is no timeline there. So in the case of all the police departments, all the sheriff's agencies, all of the DPS, whoever it may be, we don't have a timeline that we have to give them. Okay, we just have to tell them you have to destroy them or seal them as soon as possible. But there's nothing else that anybody can do. As long as they're not releasing them, you should not have a problem. But there's no timeline there. But for the district clerk, they do have to get rid of everything that they have in their possession within 30 days. Once your records have been expunged, you are going to have a very hard time getting them back. So if you go through this process and you get your records expunged, and then you decide that you want to join the Army, or you decide that you want to become a doctor or a lawyer or a nurse, those are federal or state agencies in some instances, or federal agencies in some instances when you're talking about Army. And they may be able to see a non-disclosed record. And in some instances, they may be able to see the expunged records. Now, I said that they're supposed to be destroyed, burned, and shredded, and that is true. But there is no oversight, I guess you can say. There's no micromanaging there. It's all based on trust. So once it's told or ordered to be done, it should be done. But in the case of non-disclosure, as I said, they're not destroyed anyway. They're just sealed. And if you go to join the Army, the Navy, the Nurses Association, lawyers, doctors, whatever it may be, or a federal agency, and they see this information and you come back and say, hey, I need a copy of whatever. Well, if it's been expunged, they're not gonna have it. If it's been non-disclosed, you can get it, but you are the only one who can get it. So if your Army captain or recruiter says, I need this information, I'm going to ask for it. I'll do it for you. It's not true. They can't. If your case has been non-disclosed, you and you alone can get that information. Nobody else is going to be able to do that for you. If your case is expunged, hopefully you can find someone who did not follow the rules and do that for you. Otherwise, it's gone. That's why I say when you get those certified copies of the order signed by the judge, you need to keep those records. You need to keep them because you don't know if you're going to need them, depending on how your path is going to go in the future. So that's what I have on that information. So I think now you know how to draft a petition. I think you are familiar with the expunctions. I think that you have learned quite a bit about the non-disclosure. So what else is there that I can teach you? Well, there is the human trafficking and compelling prostitution. Such an interesting topic, I know. If you are a victim of human trafficking or you are a victim of compelled prostitution, even though you may have picked up a case and been charged as a prostitute or been charged in some way from your unfortunate, I don't want to call it captivity, but that's kind of what it is. If you have picked up a charge and you've gone through that, you are going to be eligible for an expunction simply because you are a victim, okay? So as a victim, you are entitled to an expunction. And so you have a right to request that. The other area that I'm not going to spend a lot of time in is Veterans Court. So if you are a veteran and you've picked up a charge and you've been sent into Veterans Court, you are also going to be eligible for an expunction after completing that program. They guide you through all of the different conditions and all of the different things that you have to do within that program. But that program ends with you getting a dismissal. And with that dismissal, you're going to be eligible to apply for an expunction or a non-disclosure, okay? So it just depends on how your case is eventually disposed of and resolved. Judicial clemency is another area. I don't do much of those, but it basically is what it sounds like, judicial clemency. You're going to be asking the judge to grant you a pardon of sorts. And with that pardon, you can then seek to have your case dismissed or expunged, or you can seek to have your case non-disclosed. It just depends on what you had, what you had to do and if there were any conditions attached to your disposition. So those are also available to you. Maybe if you don't qualify for some of the others, or if, say, you had some of those conditions where you had restrictive means or attachments, or you had the other caveats that didn't allow for you to apply. So judicial clemency may be an option for you. I'm going to say that it's probably very rare that you will get granted clemency on your offense, but it's worth a shot as a last resort if you've tried everything else or you don't qualify for anything else. So those are the forms of expunction. Those are the forms of non-disclosure. I've told you about the petition. I guess now we can talk a little bit about the cost. So for an expunction, you have two options when it comes to costs. As an example, you have a charge filed, you've been arrested for, what haven't I used yet? Marijuana. Marijuana, very good. Okay, so you have an arrest for marijuana and they find that it actually wasn't marijuana, it was actually some rosemary that you got from your grandma's garden, and they thought it smelled pretty potent, but it was just the potent rosemary smell. Well, they don't have probable cause at that point to charge you and they have to dismiss your case. But you've been arrested for it, right? So it's on your background. It's not going anywhere. Even if they dismiss it, it doesn't go away. What you need to do is file for an expunction, and you're entitled to one. They can't prove their case. They don't even have PC to go forward. That charge, if you do it within 30 days of that dismissal, is zero. Big fat goose egg. See, zero. Doesn't cost you anything. But you do have to draw up the petition or get a lawyer to do it, and that may cost you something. But the filing fees for it is zero if you do it within 30 days from the day your dismissal is signed. Remember that. You only have 30. After that, you're going to have to pay. And if you do have to pay, because it has been 31 days since the judge signed that dismissal, or maybe you thought you'd come back to it when you had the money to hire that lawyer and you're on your 31st day. I'm sorry, but it's not going to be zero anymore. Now you're going to be paying between $300 and $400. Sucks, I know, but that's what you have to pay if you want to get this thing off your record. It's the same cost for a non-disclosure. If you do it within 30 days, you're good. It's free. If you wait until that 31st day because you were trying to save up to hire a lawyer or you were trying to figure out how to do the paperwork yourself, it's going to be about $300 to $400. And it could be more, because if you list a host of different agencies that you want to delete or seal your records, they can charge you per agency if they wanted to. And I've had that unfortunate experience with some of these smaller counties. I won't name names. I won't name names, but in some of these counties, they actually charge me $5 for every agency I list over their allotted time, over their allotted number. So I try to list everybody. I list Experian, I list TransUnion, I list Equifax, I list publicdata.com, because they buy these records. And if you don't seal them or destroy them from those agencies, they're still out there. And I have people, not often, but one every 10 years that says, hey, you did that expunction, but someone found it. And I said, oh man, well, did you send them a copy of that certified order that the judge signed? Because if you did, they have to remove it. If you didn't, then that's what I'm gonna do, but I'm gonna have to charge you to do that. And I don't wanna do that. So those are the costs, okay? If you do it quickly, even if you have to, hire a lawyer or maybe do it yourself, if you think you can weather the storm through all of this, you can get it for nothing. But if you have to pay for it, then it's gonna be between $300 and $400. And like I say, some of the agencies may have an additional charge if you go over their allotted amount of, 4 or 5 agencies listed. So for me, I think my petitions have about 12 or 15 agencies in them. I want to make sure that nobody has your records when you're done. So that is something that you also need to know. That's the cost. I think that I have just about covered everything. Let's see if there's any chat from anyone. No, I don't see any questions. If you have any questions, you can put them in the queue and I will try to answer them for you. If you don't have any questions, then it's been my pleasure providing you with this valuable information on expunctions and non-disclosures. And I hope that it's been useful to you and for you. And I'm Annie Scott. Thank you.